All right, we started the show today, our question of the day, about a situation that took place in Lindsay, Ontario, where a man minding his own business in his residence, and his home is broken into. Someone gets in, and that person actually has a weapon. Long story short, they get into a tussle, I guess. The assailant is stabbed. He has to be air-flown, like medevac, to Toronto because his injuries are serious enough they can't be treated there. And reaction to this, by the way, has been rather swift, and I would say a majority of people, and certainly when we asked the question, majority of people said, wait a sec, are you telling me that this gentleman who was protecting his property and his life, he is the one charged right now with aggravated assault and assault with a weapon because he had a knife? And I guess there was a confrontation, and it turns out the assailant is the one who broke into his home, is the one who ended up with life-threatening conditions, while this man was arrested by local police and charged. So, I mentioned at the time in setting up the question that we have laws in Canada, and yes, you are allowed to obviously use self-defense, but it comes with restrictions, if I could say that, and that restriction is reasonable force. So I was reading this story and came across our next guest's opinion on this, and I thought we should share this because I'm going to ask the question again when we come back after 4 o'clock. Self-defense is allowed in Canada, but as I said, there are limitations. So let's try to find more on this story and say good afternoon to Tonya Kent. She's a criminal defense lawyer in Toronto. Ms. Kent, thank you for being on today. Appreciate your time.
Thanks for having me. Good afternoon.
You were reading online, I understand, people's comments on this. And as I said, most of the people, virtually everyone, said, wait a sec, if I was in this situation, I would have done the same thing this person did. And what do you tell me? That I would have been arrested for basically protecting myself? So explain why in this particular case, although to be fair, we don't have all the details yet, why is sort of that the wrong approach here?
Right. So what the situation is that the police in this circumstance likely thought that there has been excessive force. Because although you can defend yourself in Canada, obviously from an intruder, there's no law that just expects you to lay down and let somebody assault you. I think people understand that. But the sort of force has to be reasonable and in proportion to the threat that you're facing. So, for example, if somebody comes with a gun, let's say, and they're pointing a gun at you, and you get a bat and you knock the gun out of their hand, and you hit them to make sure they're not going to get up and get the gun or get you again, you can do that, and that's not going to be a problem. But let's say you hit that person and they become unconscious, and then now you're hitting them in the head with the bat 20 times after they're unconscious. If they're unconscious, the threat is over. So that is where the police, I'm not saying that's what happened here, we don't know the facts, but how the police are looking at it right now until the court decides is that whatever force was done to this intruder was excessive in the circumstances versus just simply defending yourself.
So the thing I pointed out to a couple of our callers was, in theory, this sounds really simple enough, right? But in practice, you're the person whose home has just been broken into. The person who you confront is armed, and we know that's the case in this particular instance. And you managed to, I don't know what happened. He picked up a knife and he stabbed this guy. You said we don't have all the information here, but if this was simply a matter of him defending himself and stabbing this person, even if he stabbed them only once, let's say he stabbed them close to the heart or in the neck, and by virtue of that, this person now has life-threatening condition, has to be taken to hospital, would that still qualify as aggravated assault?
So the aggravated assault essentially is when you either wound, maim, disfigure, or threaten the life of someone. So an aggravated assault, like a regular assault, like a simple is like you could push somebody and that's an assault. But something that affects your life and that your life is in danger could be considered an aggravated assault. And now, just because the police charge this individual doesn't necessarily mean that a judge will not say, you know what, this was reasonable in the circumstances. I think the hard thing with self-defense cases is it's very situational to specific. It's situational to you as an individual, to the circumstances, what's going on in your house. So, for example, if I have a baby in my house, and let's say that person is advancing up the stairs, that is going to inform the way I react. And when a judge is looking at that situation, they're going to look at that situation and say, is this reasonable in the circumstances that this particular person is in under those particular circumstances?
Now, I don't know, did you happen to hear what Doug Ford said with respect to this?
Yes, I did.
Okay. So this is the Premier of Ontario, who I think reacted the way most people probably would, which is, what the hell, his words were, something is broken. So, go ahead.
I don't know. Doug Ford is a politician. So I'll say that. But at the end of the day, if he's saying something wrong has gone on, the issue here is that we don't have all the facts. And if I recall correctly, the last time that Doug Ford made a comment about Umar Zamir, I don't think he walked it back, but there were some errors in the way that he viewed that situation. So I say in this situation, I'm not saying that this man is guilty or not guilty. We don't know the full circumstances, but I don't think someone can say that there's something that's gone wrong that you can't defend yourself, because we don't know within the law what has happened in that particular circumstance. We've heard that this person was seriously injured. We've heard that they were airlifted out of Lindsay is like a smaller kind of town. We've heard that they've been airlifted to Toronto, which is the main city, probably to a trauma center. So we don't know what the extent of the injuries are. We don't know how far this person went, or that the police saw that they felt like this had gone that far. So I think when politicians are making comments, I think we should learn that we shouldn't make those types of just blanket comments until we have all the facts.
Okay, fair enough. I would ask one other question. I'm not sure if this is fair. If it's not, that's fine. Let me know. Let's take the case here of what happened, right? Someone breaks into someone else's home. We know that person was armed. By the way, to be fair, should point out that the assailant in this case has also been charged, right? I think there are 4 counts against him, right? So let's say you were that person, someone breaks in, and in this case, we understand the gentleman had a knife. Let's just say, for example, you had punched someone, right? And after you had punched that person, they fell to the ground, hit their head, and then eventually died, right? And all you did was punch them once, which seems to me like reasonable force if they have a knife. What would happen in a case like that?
So in a case like that, the issue of the fact that the person was somehow died, like if they tripped and fell and busted the back of their head open, you couldn't have foreseen that. And the fact is that your punch is reasonable in the circumstances. The fact that that person died, it doesn't necessarily mean just because somebody died that it has to be that charges are later. It has to be that you're found guilty at a trial or anything like that. Because in that circumstance, if you're saying, look, this person had a knife and I punched them to get them away from me, that wouldn't be seen as unreasonable. Even if the person died, things happen. That's why we have different levels of, murder, first-degree murder, second-degree murder, manslaughter, criminal negligence, cause of death, all those types of things. I'm not saying anyone should be charged with that in that circumstance, but not necessarily that there would even be charges laid in a circumstance like that if someone defended themselves.
Last hypothetical. Thank you for playing along. Let's say this situation plays out, okay? And now this gentleman let's say the assailant here is okay. He's going to be eventually, dismissed from hospital. He won't die. Mm-hmm. And then this goes to court, and it becomes an actual he said versus he said. I understand it's 2 gentlemen in this case.
Yes.
Then it's just one person's word against another. What happens then?
So if I was this individual's lawyer, surely I understand that the intruder has a criminal record. It was noted in some article previously. And he was actually wanted at the time, and I think has break and enter on his record. So if I was the defense lawyer for this person, I would be fine with that person taking the stand, because at the end of the day, the fact that they're already breaking in this home, and the fact is I would be asking questions about their criminal record, that they've done this before, if there's violence on their record. So the fact is the credibility and the reliability of that witness comes into play. And if I have my client who has no criminal record, who's never been in trouble before, who's saying, look, this person came at me with a knife, it's not going to be so credible or reliable, hoping that the defense lawyer's cross-examination is great, not going to be so credible or reliable for someone who's wanted for and has, offenses of B&E on their record, broken, is charged with possession of a weapon, to say, oh, no, I didn't brandish a weapon. It's going to be the believability of the stories between the 2 people. And I can say right now that obviously when people have certain things on their criminal record, if they have a history of violence, that person's coming to the court as a witness. So all those things are open season for the defense lawyer to ask about. So for sure, yes, it is he said, but there's going to be credibility and reliability that comes into play.
Well argued, Counselor. All right. Thank you very much. Very much appreciate your time today.
Yes, no problem.
Take
Thank
care.
you.